Hey everybody, welcome into the back room. I'm Andy Ostroy. We have constitutional law professor Aziz Huq with us today. We'll chat with him in just a second, but first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So, Aziz Huq is the Frank and Bernice J professor at the University of Chicago Law School and associate professor of sociology. His books include How to Save a Constitutional Democracy, The Collapse of Constitutional Remedies, and The Rule of Law, a very short introduction. His scholarship is published in leading law, social science, political science, and criminology journals. He also writes for Politico, the London Review of Books, and many other general interest publications. Before teaching, Aziz represented civil liberties claimants with the Brennan Center for Justice and worked for the International Crisis Group in Afghanistan, Nepal, Pakistan, and Sri Lanka. He was also a law clerk for Judge Robert D. Sack of the U.S. Court of Appeals for the Second Circuit and Justice Ruth Bader Ginsburg in the U.S. Supreme Court. His latest opinion piece in Politico is titled, Will the Supreme Court Stand Up to Trump if He Sends Troops to Chicago? The military isn't supposed to act as a national police force. Professor, welcome into the back room.
Thanks for having me, Andy.
So this week, the U.S. Supreme Court handed Donald Trump a huge victory in lifting restrictions on immigration raids in L.A. This is unconstitutional racial profiling, plain and simple, is it not?
I think the facts to bear in mind are that the Supreme Court is intervening at a very early stage of the case in a context in which it has no meaningful familiarity with what's happening on the ground, and in particular, whether there is unconstitutional racial profiling happening. And it's overturning the judgment of actors who are far closer to the ground, who have much better ability to discern, to tell whether unconstitutional racial profiling is occurring. And if I had to draw an inference from this ruling above and beyond the kind of special, exceptional zone, the Calvin Ball zone that seems to apply when the Trump administration is a petitioner, it's the difference between the way that the court treats allegations of discrimination involving white plaintiffs and the way it treats discrimination claims involving plaintiffs of color. Consistently, the court bends over backward to read evidence in cases of challenging affirmative action, challenging measures in which a white plaintiff is seeking to oust government action. It gives every benefit of the doubt to those plaintiffs. And here we have a case in which there's credible evidence that cuts in the direction of similarly situated plaintiffs of color, and the court does something very different. So I think that tells us a lot about how this court approaches questions of race.
And also from an optics standpoint and how the administration is spinning this. I mean, you have border czar Tom Homan all over the news, and, they continue to insist that they are going after criminals, that this is not a broad-based sweep of everyone who's entered the country. But then they say, yes, if you've entered the country illegally, we're going to round you up. And so the issue is, who are they rounding up? How do they tell? And he insists that there's so much research and investigation and video surveillance that's taking place, but we all have eyes. We see what's happening. We see people that are just being pulled out of cars and being rounded up at Home Depots when they're looking for day laborer type work. Schools, there are people who are going to work, paying taxes, people whose children have served in the military. And so it does feel like the court has just said, go ahead, do what you want, which is kind of terrifying.
I think across a number of different areas, we see the phenomena that you're describing, Andy. And the phenomena is what we lawyers or legal scholars call deference shading into derogation. Mm-hmm. And here's how I would explain that. There are many domains in which the executive branch has long claimed what it calls deference. That is, when we make a factual claim, you, the federal courts, have to acquiesce to our factual claim. For example, if we claim that there's an emergency, if we claim that X group poses a threat, the court is supposed to accede to that factual claim. And this approach of deference has long worked because administrations have not abused the leeway that it gives them. Administrations have generally come into court with a measure of evidence, and they have avoided making factual assertions that are at odds with the widely accepted public record. Not so the Trump administration. And this is not just a question in the roundups that are likely to now occur in LA and elsewhere. It is a question that arises time and again across the panoply of cases that have been brought against the Trump administration. For example, think about the allegation that the Tren de Agua gang is engaged in some kind of invasion of the United States. Think of the allegations against individuals who've been shipped to the CICOT facility in El Salvador and who are asserted to be members of this gang. Think of the basis upon which tariffs have been levied against a nation like Canada, right? The basis of the Canadian tariffs is the claim that there is a flow of fentanyl across the border from Canada to the United States, a claim that is belied by the government's own data and statistics. So across the board, the Trump administration is employing an accepted legal doctrine of deference, an accepted notion that, look, we, the executive branch, will often have more information than you, the judge. But they are doing it in a way that moves us into a domain of where I think that the government's behavior can be called abusive. And what's being abused is both the trust that's been accrued over years between the government and courts, and the trust that is invested by we, the public, in the courts. Because as you say, if we, the public, watch judges acquiescing to claims about the world that we know are patently untrue, are we, the citizenry, likely to maintain our faith in the courts? I think one of the losers here that I think has not been fully recognized is the public's trust in the courts, which is already fragile, but which I think the court is taking a hammer to as we speak.
And the Supreme Court, when it's making rulings like this, especially like recently, it's doing so without any real explanation or, more importantly, any real guidance to the lower courts, right? So it's kind of leaving them in a lurch on how they're supposed to move forward when the Supreme Court says you have to follow and obey our rulings. The lower courts are like, well, we would if we knew what you want us to do.
I think there's two parts of that. I think the first part is that the court is often deciding these cases without adequate briefing or argument. So it's literally people are losing their constitutional rights without a day in court. And just to be clear, that there's nothing new about that. A couple of years ago, I wrote a book called The Collapse of Constitutional Remedies, which went through each of the different species of mechanisms that courts have developed over time to hold the government accountable, things like injunctions, things like damages actions. And it turns out that across the board, the Rehnquist and the Roberts Court have undermined those mechanisms, particularly when it comes to the government using violence against citizens. So absolutely, you're right. This is another instance in which people are losing their rights without an opportunity to have their day in court. But separately, it was established legal doctrine that the orders that are issued on what's called the emergency docket, it's come to be called the shadow docket, are not supposed to have precedential effect. They are not supposed to be binding on lower courts because they are not issued on the basis of argument and reasoning. And yet, multiple justices like Gorsuch and Kavanaugh have chastised lower courts for failing to heed these non-precedential rulings. So I think that there's plural failures here of certainly the kind of scrupulous attention to process we ought to expect from our judges, certainly the kind of transparency and consistency of method that we expect of judges. And this is quite in addition to the manifestly unequal way that Republican and Democratic administrations have been treated by the Roberts Court.
And we've been hearing a lot in the last couple of weeks about the shadow docket. Can you help us understand what exactly that is?
So the Supreme Court hears cases in a couple of different ways. The usual way is for a case to be decided in a lower court, the district court first, and then a court of appeals, and then that reasoned opinion to be raised through a mechanism called a certiorari petition to the US Supreme Court. That's a process that takes months, if not years. What's now happening is that at the very beginning of litigation, when the first instance court, the district court, issues something like an injunction or a preliminary injunction or a temporary restraining order or some interim relief, the Trump administration is rocketing that or is using that as a platform to rocket the case up to the Supreme Court, where it knows it has a much more favorable audience, where it knows it has a bench that is much less attentive to law than the district courts or the courts of appeals. And notice that the courts of appeals and the district courts are all ideologically varied. It's not like they're uniformly Democrat, right? So you have a mix of Democratic and Republican appointees who have not been selected through this pressure cooker of the Supreme Court appointment process, which pushes toward the most politicized persons, right? Being circumvented through emergency appeals of preliminary orders. And those emergency appeals, which are decided without much hearing, without much argument, are called the shadow docket or the emergency docket.
And it seems like, you've alluded to this, that it's a very calculated strategy of Donald Trump and the Trump administration to exploit this shadow docket opportunity.
I think that if any competent lawyer, regardless of their political views, if they were to see the pattern of behavior on the part of the courts, would be irresponsible not to take this pathway. Because your job as a lawyer is to represent your client, whoever your client is, and to do whatever you can within the bounds of the law to advance the interests of the client. Now, there's a couple of complications there with government lawyers. We have special obligations. But the fact is that what the Justice Department and lawyers here are doing is just what a competent lawyer was doing. They're taking advantage of an opportunity that's been opened up by the justices. And so I don't think one should think about this as a kind of bad faith behavior on the part of the Trump administration. I think the lawyers on the government side are just doing what lawyers always do. They're using the opportunities that are available to them, and that's completely fair game. Mm. What the issue is there's an asymmetric pattern of opportunities that's open to the government. It's not open to anybody else, and the government is prevailing in those opportunities that it, but not other litigants, have in ways that short circuit other people's right to procedure, right to a day in court, right to a full airing of their interests before their interests are cruelly cut short in the way that I'm sure will happen in Los Angeles as a consequence of the opinion earlier this week.
Mm-hmm. And there was another ruling that the Supreme Court handed down, which gave Trump another victory, which was concerning his firing this past March of FTC Commissioner Rebecca Slaughter to remain in place.
That was an opinion, or that was a ruling from just the Chief Justice, not for the whole court.
Right.
It is part of a pattern of rulings in which the court has allowed the president to fire officials from a variety of what are called independent agencies, notwithstanding congressional statutes that were signed by the president in power at the time, saying this person shall not be fired unless the following conditions are met. And the
right.
purpose of these statutes, the purpose of this protection, is to make sure that certain functions of government are somewhat insulated from partisan control. Because
right.
some things that we want to have done that we do not want to have done in a partisan way. And it turns out there's actually lots of things like that, right? We want fair election administrations. We do not want prosecutions or investigations that are partisan in nature. I could go on, right? There's good arguments for why the Federal Trade Commission, which regulates media, ought not to be too partisan, right? You're in media, you know this. The Supreme Court appears to have thrown that doctrine out, with the exception of the Federal Reserve. Of course, the president is in part calling the Supreme Court's bluff with Lisa Cook firing, and we'll see how far that goes.
Yeah, the pattern here is that, we have the fear collectively that we're going to end up in a constitutional crisis if we're not already there, because the administration may be defying court orders, maybe ignoring, with the help of the court, ignoring decades old statute and law, firing people when he's not supposed to, meddling in independent agencies when they're supposed to be kept independent. You mentioned Lisa Cook. Also, he's gunning for Fed Chair Jay Powell. And in this particular case with the FTC, this is all happening within just 9 months of the administration. So is the ground becoming more and more fertile for him to continue marching through in his autocratic overreach? And the bigger concern is, where does that lead to?
I think there's legitimate reasons to be concerned about the integrity of coming elections, both in terms of the possibility of repeats of the kind of private violence we saw in 2021 and on January 6th. I think that the earlier executive order concerning voting machines raises concerns about when and how the federal government or federal law enforcement might be directed to interfere in the counting of ballots. Obviously, the push on gerrymandering and the efforts to roll back the Voting Rights Act are not direct attacks upon a particular election, but attacks upon the structures. Think about it like a house. A fair political process is like a house where you can enter in the door, but in order to enter in the house, you need certain foundations, and the foundations need to be secure and stable in order for the house to work. The attacks on the Voting Rights Act, gerrymandering efforts out of cycle are all efforts to undermine those foundations. So we're seeing multiple levels of attack all at one time. And I think that there's every reason to be, and I haven't even talked about attacks on the media, which is also an important part of the political process.
Or troop deployment in American cities.
Right, small detail.
Yes.
Can I just go back to one thing you said, Andy?
Sure. Yeah.
I disagree with you a bit. So
yep.
I'm a little allergic to when people use this phrase constitutional crisis, because I think that it's a phrase that gets bandied about, including by people who generally agree with the claims that I would agree with. But I think it's poorly defined and doesn't always help us think about the situation. And here's the question that I would ask as a citizen. Here's the thing that I would want to know. What I would want to know is the government constrained? When the government brings its awesome power, whether it's the power to grant or withhold funding, whether it's the power to deploy troops, whether it's the power to investigate or prosecute, is it constrained by law? Or can it choose to follow the law when it wants to and to set aside the law when it doesn't want to? And that's not. I don't know if the word crisis helps us think about that possibility, because I think when people imagine what a crisis is, they have in mind a kind of particular sharp moment. And what I think is of concern is not a particular sharp moment. It's a general state of affairs, a state of affairs in which we are bound by the law, but the government is not, because the government can choose to turn on or off the law when it wants to. And that's not, I don't think that the term crisis really captures that, so I kind of resist that terminology, but I hope I framed it in a way that is, at least gives people an alternative to the crisis framing.
Sure. And, not to get into a semantics game, but when you focus on all the things you mentioned that are happening in this country, I guess there's a lot of folks who say, call it whatever you want. It just feels like our democracy, our judicial system, it's all being tested in an unprecedented manner. And we're actually seeing some of the safeguards failing. And we've seen that throughout history with other democracies that have fallen to autocrats, dictators. And it concerns a lot of people.
I happen to be sitting in Milan for work purposes. I'm sitting down the street from the place where the very first meeting of the Italian Fascist Party happened. I'm sitting down the street from the place where, from 1919 to 1921, in this incredibly short span of time, you went from a world in which there was a lively democracy to one in which, if you were a Republican or a socialist, if you had been elected and you walked out in public, you were at risk of being grabbed and beaten by the squadrati. I think I'm pronouncing that right.
Yep.
It's really important to, history is really important here in the following sense. It is really important because it is a resource that reminds us how darn quickly change can happen.
There was a lot of other cases that were decided on the lower court level in the last week. This included over the deployment of National Guard in Los Angeles, declaring it as illegal, preventing Donald Trump from using the Alien Enemies Act to deport Venezuelan immigrants, stopping Trump from cutting $2 billion in research funding to Harvard, something you've alluded to before. Appeals court ruled that he did not have authority under 1977's International Emergency Economic Powers Act to impose most of his tariffs. How excited or not should Democrats get over these rulings? Or, as we saw with SCOTUS's overturning of the lower court's ruling on the FTC commissioner's case, can we expect these cases to all head to the nation's highest court again, where, as we've seen with this pattern, with this significant conservative majority, they're just going to rubber stamp all of these, and that's where he'll get his victories. Where do you think these cases are going?
I don't know the answer to that, and I think there's a bit of what was once called Kremlinology and trying to figure out what the court thinks it's doing. And I'm not in their head. I don't know what they're talking about. I just don't know. It's certainly the historical record of what they've done over the last 8 months inspires no confidence. I do think we're in this actually historically unprecedented moment at which there's this fragmenting of the federal court system between, on the one hand, a hyper-politicized Supreme Court and, as I said earlier, a bunch of lower courts, including, you mentioned the Alien Enemies Act. It was a Fifth Circuit case that was not, by no stretch, a kind of liberal panel. Mm-hmm. You have a bunch of lower court judges just doing their jobs and basically being told by the Supreme Court, don't do your job. Now, again, at some point, doesn't that become a crisis of confidence in the Supreme Court, right? A court that was already, is already at a historic low in terms of its the trust that people have in it. A court that was already the subject of an enormous amount of debate with respect to whether there was structural reform needed. A court that appears to act as, to use your words, a rubber stamp to a partisan-aligned president, but which is reliable in striking down the ordinary regulatory initiatives of a non-partisan-aligned president. Gosh, that's not a court that a democratic political system can easily live with.
Yeah. My last question concerns the deployment of National Guard troops in D.C., but also now the threat as well in Chicago, Boston, Baltimore, and elsewhere, if you listen to the president. There's a big distinction between what Trump was allowed to do in D.C. versus any other city. Also, what he did in L.A. There's so much that is involved in these cases. Can you help simplify it for those of us at home who are just trying to understand the law in terms of when can he send troops, where does he have overriding authority, and where doesn't he?
I would divide the law into two questions. The first question is, when can the president take control of the National Guard? And the second question is, what can he use the National Guard to do? Right, let's do the first question first. The law on the question of when can the president take control is different for DC as opposed to any other place, because it's long been understood, rightly or wrongly, that the president already has direct control of the DC National Guard, but doesn't control the National Guard of other states, Puerto Rico, Guam, or the Virgin Islands. That's why DC is different. That's the first question. The second question is, what can the president do with those troops? There is an 1878 statute called the Posse Comitatus Act that says that the president cannot use troops in the homeland for law enforcement purposes, absent an explicit exception in another statute. Now, this is where the law gets complex and murky, and this is where the District Court in California opinion that you mentioned intervenes. What I think is useful to know is that the Posse Comitatus Act is written in broad terms and in vague terms that have never been clarified through litigation. So we don't know what counts as a law enforcement activity, and we don't know what it takes for something to be an exception to the Posse Comitatus Act. There are lots of exceptions. There's something like 26 explicit exceptions. And some of those are well written, some of them are badly written, some of them are scarily written, the Insurrection Act in particular. But it's not even clear that that list is exhaustive. And so the way that the Posse Comitatus Act translates into a prohibition on the use of troops for law enforcement purposes turns out to be really hard to predict, because the law is just a mare's nest of complexity, and that mare's nest has never been resolved by courts, because presidents up until now have been pretty careful not to use the military in the homeland.
Yeah. And quickly, the governors really don't have much recourse, do they? Other than to sue like Gavin Newsom did and hopefully win.
Yeah. Well, so the statute that permits the federalization of the National Guard has language in it that talks about the governor being the conduit through which that federalization occurs. California argued, I think rightly as a matter of just reading the language of the statute, that language was added in 1908 to the statute so as to give the governor a veto. I think that's quite a plausible reading of the statute based upon the text and based upon the context. 1908, what's going on? Labor unrest, right? And governors may well be very sensitive. Hey, we don't want federal troops coming in here because that's not going to quell labor unrest. That's going to lead to wildcat strikes all over the place. Yeah. So it's a very plausible reading of the statute. The Ninth Circuit, in an opinion by two conservative judges, gave it, I think, a comically dismissive back of the hand. But that ought to be a serious argument. So I do think governors have a role. What I would suspect will happen is that they'll be much more relying upon red state National Guards. Although, of course, the idea of bringing National Guard from state A to state B in order to repress First Amendment activity in state B raises a whole host of other federalism and, are we one nation questions that I think are just as hard.
Professor, great insights. Thanks for coming on. And I do hope we'll get a chance to chat again sometime.
Great to be in conversation, Andy. Take care.
All righty, take care. This episode of The Back Room was edited and produced by me, Andy Ostroy. It was co-edited and co-produced by Maddie Rosenberg and co-produced by Jen Hammoud. Our theme song was composed by Andrew Hollander, and our logo was designed by Cricket Langell. And special thanks to Patricia Wind. Please take a moment to rate and review the podcast, and also follow or subscribe. Until next time, keep your eyes on Washington, Hollywood, and your own backyards, and have a great week.